critical mass of attendees joining the call at this point, so let's get started. Welcome to all of you, clients and friends of the firm. Hope everyone is staying safe and healthy under these most unusual circumstances. Before I introduce our presenters this morning, a quick reminder to keep your lines muted to avoid background noise so that you can hear what our presenters have to say and we're not disrupted by the background noise that comes attendant with a remote working solution that we're all getting used to on more and more on a daily basis. In any case, thanks again for joining us today under these unusual and unprecedented times and circumstances. Today's discussion topic is navigating the ever-changing real estate landscape and how the CARES Act may impact it. Unprecedented times call for new formats. So this is a new format which we are trying out here. Our goal is to have a fluid and dynamic conversation with all of you. But again, due to the nature of this format, we ask that you keep your lines muted. I'm going to give you in a few moments, though, some instructions as to how you can submit questions to our panel, which I will then ask of the panel. So I think this format works best when you're active and engaged, and we certainly want to be answering your questions. So once I give you those instructions, please feel free to use the website and email address to contact us with your specific questions. I am Eric Williams, your panel moderator for today. For those of you who do not know me, I am the chair of Saul Ewing's Real Estate Practice Group. I represent tenants, landlords, buyers and sellers of real estate, borrowers, developers, really all facets of the real estate industry, both locally and nationally. My practice is concentrated in project development in healthcare, higher ed, office, retail, hospitality, and the industrial spaces. Like my colleagues on the panel today, I am seeing the impacts of this pandemic ripple through our entire industry and impact in some way, shape, or form virtually every project and every client that I work with on a daily basis. From higher ed shutdowns to tenants not being able to use their spaces, to landlords having to implement enhanced cleaning protocols and closing down their buildings and getting requests for rent relief, to construction project moratoriums, to lenders delaying loan closings. There is not a facet of this industry that has not been impacted by this crisis. My career as a real estate attorney has now spanned 3 recessions and 3 recession-inducing events, which have led to real estate market downturns. 9/11 initially, the 2008 financial crisis, and now the COVID-19 pandemic, which shares certain characteristics with both of the prior downturns, but is also unique in many respects. During the last recession, I worked on loan workouts, closing on distressed assets, and generally helped clients weather the downturn storms. So regrettably, this is not new territory. It has obviously characteristics which are different from prior downturns, but this is not new. Before I introduce our presenters, I want to share a few housekeeping notes. Again, because all of your lines will remain muted throughout the call to avoid background noise, I will be the one asking the questions, both questions that you attendees submitted prior to this call and questions which you can submit during the call. If you care to submit questions to the panel during our call, please do so by using our Q&A email account. That email account is events2@saul.com. That is EVENTS, the number 2, at Saul, SAUL.com. We will do our best to answer all of those questions, and should we run out of time today, we will follow up with you individually with responses. Before I get into introductions and introductions of our panelists and the substance of the presentation, a quick legal disclaimer. In this format, it is important for all of you to know that the provision and receipt of the information in this presentation is not legal advice, does not create a lawyer-client relationship, and should not be acted on without seeking professional counsel who have been informed of the specific facts of your issue. We are happy to do so after the call and consult with you directly, but today's presentation is here to help you think through some of the issues, identify issues, and then pursue additional counseling regarding the same. So turning to our speakers, we have assembled a strong panel today to help walk through the issues that all of you are facing in this present and under present circumstances. Our first panelist is Richard Lee. Richard is a business lawyer who concentrates his practice in two areas: commercial contracting, which involves drafting and negotiation of complex commercial agreements across a variety of industries, including real estate and business, and debt financing, generally on the borrower side. Richard is a former commercial banker. Richard, can you please say hello to the attendees so that they can hear your voice and identify you?
Yes, thanks, Eric. My name is Richard Lee, as Eric said. Happy to be here today, and hope that you enjoy the presentation.
Thank you, Richard. Our second panelist is Beth Fenton. Beth is a trial lawyer practicing principally in Delaware and Pennsylvania courts. For more than 20 years, she has litigated disputes for businesses about leases and other contract rights, indemnification, and piercing of the corporate veil. She also serves as a judge pro temp for the Commerce Program in Philadelphia Court of Common Pleas, where she assists in pretrial dispute resolution efforts. Beth, can you please say hello to the attendees?
Thank you, Eric, and welcome to all the attendees.
Our final panelist today is David Falcone. Dave is a partner in the firm's real estate department. He is licensed to practice in Pennsylvania, Delaware, and New Jersey, and works primarily out of our Chesterbrook, suburban Philadelphia office. Dave focuses his practice on a variety of real estate matters. Specifically on the transactional side, Dave represents landlords and tenants across the country in office and retail leasing matters, and buyers and sellers in the acquisition and disposition of real property. Dave also works closely with developers in southeastern PA in all aspects of development, including financing, local permitting, land use, and the formation and implementation of planned communities. Dave, can you please say hello to the attendees?
Hi, everyone. Thanks, Eric. Happy to be here.
Okay, before we turn to the specific questions to the panel, a little bit of context. As we are all sort of painfully aware at this moment, we're witnessing and experiencing in real time an historic event with unprecedented impacts on our economy, our personal and social lives, and likely all of our professional lives. Robert Kennedy's quote, "May you live in interesting times," has never seemed so appropriate. These times are all too interesting. The real impacts began about a month ago when international health organizations like the WHO and CDC started issuing directives suggesting that public gatherings be suspended. This is when, as real estate attorneys and attorneys practicing in the real estate industry, we first started getting questions from our clients about how to address the impacts. What followed quickly was government-mandated social distancing, restrictions on the operation of non-essential businesses, and governmental orders for citizens to shelter in place. This has resulted in an unprecedented and largely unanticipated disruption to national, state, and local economic activities, which is touching virtually all industries and because of the nature of the pandemic, is having a particularly pronounced impact on the real estate industry. At the Main Street level, hotels, restaurants, bars, entertainment venues, retailers are forced to close, and these are businesses that cannot, in any real sense, operate remotely. This puts massive stress on these businesses to cut costs, and their two biggest expenses are people and space. Last week, we saw massive amounts of employees being furloughed and terminated across the country. The New York Times and Washington Post are reporting this morning that 6.6 million people applied for unemployment last week, a historic number of unemployment applications in a week's period of time. The space issues are dropping as we speak. Tenants across the country are reaching out to their landlords seeking rent relief, abatements, deferrals, restructured leases. This is putting stress on landlords who are in turn looking to their lenders for debt service relief. Federal and state governments are stepping in, attempting to address the situation, prohibiting evictions and offering grants and stimulus dollars to businesses, tenants, and landlords in order to make payroll payments and otherwise continue their operations during this unprecedented stoppage of economic activities. At the same time, construction projects are being shut down. The state of Pennsylvania did not include construction in exempted essential businesses, so construction has been shut down in Pennsylvania for several weeks now, and we just found out this morning that New Jersey has issued an order closing construction sites with a few limited exceptions starting almost immediately. There is going to be a few days to allow construction sites to demobilize and secure themselves, but this is going into effect right away. This is the environment that we are all operating in. It impacts tenants, landlords, lenders, real estate buyers, real estate sellers, all manner of real estate owners and operators, and all parties that work to support their activities. And this is the context in which we are assisting clients address issues and confront the implications of this pandemic. So with that, I want to turn to our panel for their sage advice. And again, one last reminder, if you have questions, specific questions related to your specific issues or things that arise as a function of this conversation, please submit your questions through events2@sol.com, and we will have those questions asked of the panel. So, turning to our panel, and let's start with Dave. With the arrival of April and the April rent obligations, we are clearly seeing a second phase of issues related to the pandemic's shutdown of businesses. In the initial phase of issues, we saw that landlords were concerned about best building practices and OSHA cleaning standards and notices regarding infected employees and how to comply with governmental shutdown orders. The second phase is now about how do these facts impact my contractual obligations as a tenant, as a vendor, as a contractor, as a borrower, and how do I work with these obligations? At the heart of this discussion has been force majeure provisions, which are in several of our executory contracts which govern our real estate relationships. Can you tell us a little bit about force majeure provisions and how they are coming into play in the current situation?
Sure, Eric, thanks. Not to kind of short circuit the question, but I wanted to just address the first part very quickly. I don't think the time now has arrived to move away from landlords and tenants being focused on the best building practices. As a general matter, I think landlords should continue to be focused on those things, and to the extent issues arise that require the landlord to kind of dig into their lease and look at the provisions there that control how they operate their common areas, that's really where we would look for the landlord's right and obligation to to control the building, to close it when necessary, to perform the necessary maintenance, to clean and do the things that a landlord would do in general best practices. So those things are still important. They're still very viable. And as this pandemic continues to move through the system, the landlord is going to have those issues and be aware of them going forward. So I just wanted to touch on that before I got to the force majeure. Force majeure is a provision, I guess, until recently, many folks would have considered kind of a boilerplate provision in their contract. It was one that didn't get a lot of focus during the negotiations. Now, folks are quickly turning to that provision and evaluating what's in it and what it means to them, both on the landlord side and the tenant side. So in doing so, they are becoming aware of the actual language of the provision being the most important thing. The force majeure concept, that which is an event, kind of an uncontrolled event, a circumstance that would forgive performance. Really, that's what we're looking to do for any party that's trying to invoke the force majeure concept. They're trying to forgive some type of a performance under the contract. So when we look to that provision, we have to look to kind of the plain language. And that's where all of the specificity around what was negotiated, if it was negotiated, during the process where the documents were being signed. What's included in the force majeure, what's forgiven, what isn't forgiven. People are turning now to their force majeure provision to see whether or not it would forgive the ability and the obligation to pay rent. In most instances, virtually all instances, you'll see that a force majeure will not forgive the obligation to pay rent. Instead, really what it's trying to do is trying to kind of make an end run on the obligation to simply perform, and what that performance is under the lease. Kind of it varies based on the tenant or the landlord. So with force majeure, Eric, we're really looking at the general landscape under which the contract is executed, but then the specific language of the provision and how that would ultimately be interpreted between the sides. If you're the tenant looking to the force majeure provision, do you need to occupy? Are you required under a lease to be in your space and occupying it and open for business 24/7 or 7 days a week from 9 to 5? Does the force majeure provision in the agreement allow you to not be open? And what does that mean? If you're not open, does it forgive any other obligations? From the landlord's perspective, you're looking down the line to see whether or not you have any performance obligations that you need to meet, whether it's a construction obligation, whether it's a delivery obligation. Are those things excused under force majeure? So both sides are definitely turning to the same provisions. And one thing that's kind of unique in this situation that we're all kind of experiencing right now is that where oftentimes you see parties very much on opposite sides of a line, I would say in the current situation, everybody is in the same situation. We're all dealing with the same force majeure event. It's just about how it's impacting that party's obligation.
Dave, a follow-up question there. Is it material as to whether, is the force majeure event the pandemic itself, or is it the governmental orders shutting down businesses currently? And does it depend on the language in the force majeure provision?
It very much depends on the language in the force majeure provision. So you're going to turn to that provision in your contract and you're going to see how it's defined. Is it defined broadly? Is it simply a clause that says we're forgiving any act beyond the party's reasonable control? Or are you looking to very specific language? Are you saying it's an act of God? It's a government shutdown? Different force majeure provisions, Eric, are kind of drafted, they're drafted differently. And some are very specific. And when drafting specifically, they're going to be interpreted specifically. As a general rule, the provisions are interpreted narrowly. So the language that's in the provision is going to ultimately drive how it's interpreted. Parties can negotiate the provision however they'd like. Some now, as we see, we've gotten calls from clients, as we look at these provisions, we're expanding the way we draft them. We're expanding it to include pandemics. But really, again, we're trying to get back to what is the actual event that caused the disruption? And did that event actually trigger the non-performance? So it's not simply saying there's a force majeure, there's an event out there, an act of God, a government shutdown, and therefore I'm not going to do anything under my contract. They have to tie together pretty closely. You need the actual event that's defined under the force majeure to be the trigger for the non-performance. And that's why in most instances we don't see that rent is abated because of a force majeure event. And we certainly don't see situations where there's now credit issues on the part of the tenant because their inability to operate. That's not a force majeure event. Simply having a short flow in cash doesn't in and of itself preclude you from performing under your obligations to the contract. So you're going to be expected to do so.
Thanks, Dave. Let's turn to Beth. Beth is our litigator on the panel and is here to give us insight into how courts look at these contractual provisions. Beth, Dave described sort of the contractual force majeure rights. Can you speak to courts' interpretation of force majeure provisions under regional state laws? And is this something that varies from state to state?
So I practice in Pennsylvania, New Jersey, and Delaware, also just like Dave, admitted in all three states. And what I would say is that in terms of force majeure, the states are going to look at what the contract says. I mean, it's really strictly a contract interpretation question. And so it's hard to draw generalizations across different clauses, different allocations of risk. I mean, that's really what the contract-based defenses are going to be. There are other defenses, though, that you could assert without having to resort to a force majeure provision. Let's say you don't have one. You're still going to be able to assert impossibility, impracticability, frustration, purpose. These are equitable defenses that aren't based on contract language. But the burden, either way, whether you're talking about a force majeure clause or an equitable defense that's really fact-based, where you're pointing to affidavits, you're pointing to the governmental orders shutting things down, either way, the burden is going to be on the party asserting the defense. And the threshold for that burden is pretty high, notwithstanding the fact that we are in, crazy times. And the reason that burden is going to be high is because essentially both sides can claim the same impossibility, frustration of purpose. So, I always as a litigator, I want to help people resolve their disputes without going to court. I think especially in this kind of situation where, courts are open, but they're not having people come into court. The AAA and other ADR tribunals also open. We've been filing cases, but there's only so much one can do virtually, and also this changes on a day-to-day basis. Pennsylvania, New Jersey, and Delaware have not said you can't do commercial evictions, but Maryland has actually come out and said you can't do a commercial eviction if the tenant can prove financial hardship. So it's rapidly changing. I don't know. Again, none of these executive orders, regardless of what they say, they don't relieve anybody of the obligation to pay rent. But the court's ability to get involved in these kinds of situations when nobody can be in the same room with each other, some courts are better at than others. But it's just not a great time to be availing yourself of those remedies, as that's certainly not going to be the first resort. I'll leave it at that.
Yeah, and so, Eric, just quickly to piggyback on what Beth was saying there, it's Dave. One of the things, so when we see these provisions interpreted in courts and in disputes, really you're working off of what they're reviewed against. And the concepts that you review the force majeure against is, and Beth, you can correct me here if I'm wrong, but it's kind of reasonable expectation, anticipation, foreseeability, or events beyond the control of the parties. So when courts are interpreting these provisions, they're looking at those concepts to determine whether they exist or whether they don't. And so, again, you're looking back at, we know that liability for breach of contract is a strict interpretation issue. What the force majeure clause is attempting to do is draft around the impossibility of that performance by kind of outlining the specificity of the failures that surround your non-performance.
Right, and the foreseeability concept is an important one. And some force majeure clauses are very specific. Some have kind of a catch-all, other similar situations. And in those, there's going to be litigation about that. And, it's not necessarily going to be happening today because people are focused on, dealing with the immediate crisis. But there's probably going to be some case law coming out in the next couple of years that talks about, foreseeability, what are those other kinds of situations. And it's not going to be easily resolvable. There's going to be trials on that, and what does that mean? Because it's a fact issue ultimately.
And so one last point on the kind of interpretation and the enforceability of the provision. Some provisions, and it's going to be, again, specific to each provision, but some provisions require some type of a notice in order for a force majeure to be claimed or enforced. So to the extent you're a tenant looking to look to your force majeure provision, or a landlord, you want to review the provision and see whether or not there's a requirement that you provide notice of the event and the impact to your performance to the other party or to a third party. Landlords have issues as well as tenants. From a tenant perspective, if you're a prime tenant under a sublease, maybe you have to give notice to your subtenant, or if you're a landlord and you have to give notice maybe to a lender. I think you want to review the provision and see what's required of you to make sure that if you go down the road to try and enforce the provision, you do it properly to make sure you preserve all your rights there.
Thanks, guys. We're getting some good questions from the audience, so I'm going to throw a couple questions out here right now to cover some of these issues. So the first one is with respect to the role insurance plays in providing coverage for the business interruption losses that tenants are experiencing right now and landlords are experiencing. So the question is specifically, how are insurance companies able to reject business interruption insurance claims, particularly for retail sites, given the government shutdown of non-essential businesses and stay-at-home orders at present? Anyone want to take that?
So Eric,
I can field that if, go ahead.
I can speak just very briefly to it, and then obviously you can jump in, but oftentimes in insurance situations, when we turn to the insurance provisions, they need to be triggered by some type of a casualty event, which is ultimately when your insurance kicks in. And what we're seeing here is this is generally not deemed to be a casualty. It's something other than that. It's a force majeure. It's an act of God or a government shutdown. So in some instances, we see insurance companies not being able to look to those business interruption provisions because the trigger event, what's triggering the call to the insurance claim, just isn't there under the plain language of the contract. I guess that's one interpretation.
Yeah, I think that's exactly right. Business interruption insurance is a commercial property insurance, and it's designed to cover the loss of income incurred by a business due to a suspension of operations, but the triggering event is a property loss. So it's a casualty oriented coverage, and I know that during prior outbreaks, earlier this century, there was SARS, rotavirus, H1N1, and during those prior outbreaks, insurance industry added exclusions to their policies designed to preclude coverage in the event of disease-oriented shutdowns. So this is something that's going to be litigated. I know of at least one lawsuit which has been filed already to seek coverage under these circumstances for COVID-19 related shutdowns. There could also be some governmental override. I harken back to 2001 after 9/11. Some of you who were in the industry at that time may recall that the reinsurers, the insurers and reinsurers disclaimed coverage for acts of terrorism and acts of war at that time. And so you were unable for a period of months to get any kind of insurance to cover liabilities related to terrorist acts or acts of war, and couldn't, a lot of construction projects had to get mothballed during that period because you couldn't get coverage, and lenders were requiring that coverage. And Congress had to step in and provide a backstop, a legislative backstop to provide terrorism coverage. And that allowed the industry to start insuring it again. There's been some discussion that the government will have to step in under these circumstances to provide a backstop to the insurance industry to allow them to apply business interruption coverage under these circumstances. But so far, there's been no headway in getting there. So another question from the audience is the current health situation, this is in the context of a force majeure provision where you're interpreting whether this falls within the parameters of your force majeure provision. Would this current health situation be considered a man-made condition or an act of God? Beth, do you want to, or Dave, you want to take that question?
Yeah, I mean, this is Dave. I don't know. I don't know
that's my answer too.
if a court would determine that to be an act of God or a man-made situation, and I don't have an answer there. I think the experts in the field are still trying to figure out exactly how and why we're in the situation we're in. So that one's tough to answer, Eric.
What I will say is that, just looking, the cases that deal with this are very old cases because there just hasn't been something like this in our lifetimes. So there's like a 1917 case from Connecticut that basically, treats the Spanish flu as a qualifying event, for lack of a better word for force majeure. But I think what's going to end up happening is what Eric said. It's going to get litigated. Courts are going to come down with interpretations. I mean, I don't. It'll be an interesting legal question, but there's not a lot of guidance right now, which is why, if you can negotiate a resolution, that's preferable, because you're going to end up, it's going to take a long time for this stuff to work its way through the courts and get some more guidance. And they're not necessarily going to be uniform. I mean, we're already seeing that different states are treating the pandemic differently, so that's going to play out in judicial decisions as well. Wish I had a clearer answer, but I don't.
No,
I think. Sorry.
Go ahead.
Yeah, I think it goes back to, Eric, we've got to look at what the obligation is we're looking to not perform, and then look at the current situation and what the cause is of that non-performance. So whether it's an act of God or whether it's a man-made act or whether it's a governmental shutdown or loss in supply chain disruption, material disruption, what is it that you're not doing or your tenant is not doing? And does that deficiency tie closely to that non-performance? That's ultimately where I think the determination is going to be made, and they have to be tied together closely.
Thanks. Okay, the next is a two-part question. Will Maryland get the same shutdown orders for construction that PA and New Jersey have received? How much notice will we get? We assume it does not include emergency maintenance such as roof repair or HVAC or parking lot repairs of a significant nature. I'll take that part and then I'll ask the second part. I can tell you that currently construction remains an essential business under Maryland's stay-at-home order. And to date, Maryland's reported cases, tested positive COVID-19 cases, remain below projections. So that does not mean that Maryland will not at some point get to a position where they think a construction shutdown is appropriate. But I can tell you, as all of you may be aware, New York is the hardest hit state in the United States currently for positive tests. And then New Jersey is coming in right behind that. Pennsylvania has taken a pretty aggressive stance in terms of governmental orders and shutdowns, and again was the first to shut down construction sites because in the view of the Pennsylvania government, construction sites are very difficult places to have mandated social distancing. In some essential businesses, you can still social distance while you're at work. At a construction site, during some portions of the project, you can, but there are other labor-intensive parts of a construction project that simply require people to be close to each other in order to facilitate. And so the decision was made that construction needed to be shut down in order to effectively flatten the curve here in Pennsylvania, which was anticipated to quickly follow New York and New Jersey in reported cases. So, and again, New Jersey has decided to shut down their construction sites for the same reason. So again, Maryland is currently, it's still an essential business. If the curve gets flattened and we don't see a peaking of cases in Maryland, it's possible that construction will remain essential. In those jurisdictions where it has been stopped, there are exceptions for emergency repairs, so you can still get that done. Of course, it's always the difficult thing is whether you can get a contractor out to do that work. The second part of that question is if a tenant can remain open as an essential business, what cleaning protocol guidelines is the landlord supposed to impose on the tenant, or is the tenant obligated to tell the landlord what they are doing and record that in a daily log in case a patron makes a claim? David, Beth, do you want to address that question?
Well, so I have seen some guidance from executive orders in various states about this. I mean, there definitely needs to be signage, like if you go to Rite Aid or CVS or other drugstores where I am in Pennsylvania, they all have signs that say, observe social distancing, and if you have symptoms of COVID-19, don't come in. We will, we can help you, but these are the things that we need you to do. So, I think it's a communication issue. Somebody needs to be doing it. It's a lease issue if the lease covers it. But, I think you just need to keep those lines of communication open and make sure it's happening regardless of who is taking care of it, because it inures to everybody's benefit if you, God forbid, did have someone, come in and cause, an outbreak or even have a slip and fall sort of a situation. You just want to be sure that's covered, that somebody's doing it and that it's being thought about.
Dave, do you want to speak to cleaning protocols, the OSHA guidelines?
Right. So I touched on that briefly in the opening, and I think really that's where the landlord is looking and can turn to their obligations in the lease. But the landlord certainly has obligations oftentimes to keep the building, the common areas clean, sanitary, and so forth. And to be able to do that, the lease will generally, or your agreement will generally allow for certain shutdowns and so forth. So it is good advice for landlords to advise tenants of the OSHA obligations. The OSHA website has them up. They can distribute to tenants what's required of the tenant, properly notice your space, and be aware of what your obligations are as the owner and the maintainer of the common areas, but then also advise tenants as to what their obligations are to comply with the regulations, not just that you set forth, but also which are coming down and are government mandated. So I think notice is important, as Beth spoke to, and then also understanding your obligations under the documents and what you can and cannot do. But certainly there are, in most documents that I see, and in the vast majority, the right to the landlord to shut down areas and to perform the maintenance that's necessary. And I would, classify this action as maintenance and keeping it, the health, safety, and welfare of your tenants, and those obligations. I would put this under that heading.
Yeah, I think that's all exactly right. And I think best practices, both from landlord and tenant, is to notify. So if you're a tenant and one of your employees tests positive that's been working in a building, your best practice is to notify your landlord that has happened. You don't want to reveal the name of the employee or any of their personal medical history, but you do want to notify your landlord that has happened. And then landlords have that responsibility, as Dave mentioned, and should be currently having enhanced cleaning protocols with respect to high-touch common area spaces, elevator buttons, elevator lobbies, main lobbies. Those should be, you should be following the OSHA guidelines for cleaning there. And then when it's been reported that an employee in a particular space has tested positive, the best practices I have seen have, as Dave mentioned, utilize the reservation of landlord rights in your lease to temporarily shut down that space, bring in a company to fumigate it per the OSHA guidelines, and make sure that you're addressing things as appropriate. And this goes to sort of Beth's sphere of expertise. These could potentially become lawsuits in the future. If folks are getting sick, if somebody dies from catching COVID-19 and there's been a report of it in the building, there could be wrongful death lawsuits. You want to make sure that you're taking all reasonable precautions and doing all reasonable measures to keep the building clean and safe. And that requires notice and OSHA protocols. Yep.
Yeah, Eric, to that point, a colleague of ours in a discussion like this made a good point. I think it's worth sharing. As a landlord, you'd certainly rather be on the side where one tenant is claiming that you've kept them out of space improperly, rather than be in a situation where you're being sued by all of your tenants for allowing an infected individual to be in your building and to not respond accordingly. So erring on the side of being overly cautious, keeping your buildings clean, following the OSHA guidelines, that would be where, I would think most landlords would want to be.
Okay, great. We're getting a bunch of good questions here. I don't want to lose sight, however, of another part of our presentation here, substantive materials. So I'm going to take a break from Wendy question, and I want to pivot to Richard Lee. Richard has some important information. We've been talking about sort of the enforcement of these contracts and discussions that can happen as between landlord and tenant and borrower and lender in terms of seeking forbearance or rent abatements or restructuring of your contracts in order to get some cash relief in the short term. The government has also put together a helpful set of tools to allow tenants, landlords, businesses, great and small, to address some of their payroll issues, rent issues, and expense issues. So I want to turn to that real quickly. The CARES Act, which was promulgated last week, I believe, or the week before at this point. It's all blending together at this point, Richard. But can you talk a little bit? Let's start with the Paycheck Protection Program under Title I of the CARES Act. Can you tell us a little bit about what the PP loans are there for, who's eligible, how much folks can borrow, what it can be used for, et cetera?
Yes, thanks, Eric. I'd be happy to. Given the date, it's April 9th, and the act was enacted about 2 weeks ago. loans started being made last Friday. I would guess that many of those in our audience today have already applied for a PPP loan or they're in the process of doing so. So I'll talk just a little bit about how the program works and some of the details. There's a lot of info out there, so I won't dwell on it. One of the things I do want to focus on, though, and this is important, there was a lot of confusion and some ambiguity as this got underway, and the Small Business Administration just 2 days ago issued some guidance, which I think is significant because it clears up some of the confusion and actually changes some of what is in the Act. So I'll address that very quickly. So in terms of eligibility, this is well known. The default rule is that the program makes available loans at a very low interest rate, 1%, for businesses with 500 or fewer employees residing in the United States. There is a well-known exception for companies in the hospitality business, so hotels and restaurants with more than one location. They are exempt from that 500 employee rule. But there's really more to it, and this was just clarified on Tuesday. 500 employees is a default rule. You really have to look at the underlying SBA rules with respect to eligibility to determine whether or not your company is eligible. So for certain types of businesses in certain industry areas, the number is not 500. It can be a higher number, up to about 2,000. You have to look at the underlying SBA rules to make that determination. There is a second test that's not employee-based at all. So for some industries, its eligibility is actually based on gross revenue up to a certain amount, which is specified in the SBA rules. And then finally, there is an alternative size standard that is based on tangible net worth and average net income for the prior 2 fiscal years. So the bottom line there, I think, is that some businesses who may have thought they were ineligible actually are eligible. It's worth taking a second look. Another question, and I'll just throw this out there, this was raised by a number of our real estate clients with EB-5 investors. What about foreign ownership? Is that a disqualifier? There was some confusion there, but the answer is no. You can have foreign ownership. It's a disclosure item, but if all the other requirements for eligibility are met, having foreign owners, even up to 100%, will not disqualify you from obtaining a Paycheck Protection loan. How much can you borrow? It's formulaic. It's based on payroll costs, essentially compensation plus benefits times 2.5. You have to exclude the portion of employee compensation over $100,000 for those employees. But there is some new guidance that clarified the concept of compensation. It's actually based on employees' gross compensation. So you can include federal income taxes that are withheld and the employees, but not the employer's share of federal payroll taxes. Also, rather than looking at just the 12 months prior to application for the loan, which may not be practically feasible, you can look at calendar year 2019 in making the calculation. One thing that's clarification that's important, it directly contradicts what's in the Act. Amounts paid to independent contractors and reported on a 1099 cannot be included in payroll costs. So that's a change. What about use of proceeds? So I think this is relevant for everyone here. The fundamental purpose of the program is to keep employees on the payroll or to bring them back if they've been furloughed or laid off. But in addition to payroll costs, permitted uses are utilities, rent, which is critical at this point, interest on mortgage obligations, and interest on other indebtedness that was incurred prior to February 15th of this year. So those are the permitted uses. One thing that was just clarified, and this is critical, to be eligible for loan forgiveness, and these loans are forgivable up to 100% of principal plus accrued interest, at least 75% of the amount borrowed must be used for payroll costs. That was not in the Act. It's a more recent clarification. What about applications? So the rollout didn't work so well. We've heard about bank sites crashing and the like because the number of applicants was far higher than anticipated. But be that as it may, it's ongoing. Note that the application form, which is based on SBA Form 2483, has been updated, I think, 4 times in the past 2 weeks. If you've already applied, your grandfather, there's no reason or no need to reapply. However, you do have the ability to update your application using one of the later versions of the form. A question has come up a lot about fees. Can a bank charge an origination fee for this loan? Simple answer is no. Banks are compensated by the SBA under the Act. They cannot charge the borrower. And then finally, what about forgiveness? That too is based on a formula. I'm not going to go into it. It's a bit convoluted, and the SBA has not yet released final guidance as to how that's going to work. Bottom line, I think, is you apply to your lender for forgiveness. You have to substantiate the amount that you're seeking forgiveness for with records such as payroll records, rent records, bank statements, the like. It's based on 8 weeks of expenditure for payroll costs, utilities, rent, and mortgage interest, not interest on other debt. As I said, up to 100% of principal plus accrued interest is recoverable, but critically, at least 75% must be spent on payroll. So,
hey, Richard.
Yes.
I'm sorry to interrupt. We have a question from the audience that is, I think, pertinent to what you're saying right now. The question is, can workers' compensation insurance payments be included as a permitted use of funds under the PPP loan program?
The employer's share, well, actually, I think the answer to that is no. Severance payments are a permitted use. I do not believe that workers' comp payments are. However, I can clarify that and get back to the audience member who asked the question today with a definitive yes or no.
Great. I'll give you that information.
Okay.
Richard, it's Dave. I have a question.
Sure.
Maybe you could speak to that I've gotten from a couple of clients that deal with the application for the PPP. What is incumbent upon the applying party? Is there an affidavit that's required, and what goes into that, and ultimately the interpretation of whether that affidavit was made correctly?
Well, in filling out the application, basically the applicant is certifying as to the veracity of every statement made. And the application is very simple, 2 pages, but it does contain a number of statements concerning things such as ownership, the existence of harm to the business as a result of the COVID-19 outbreak, and there are a number of other things. One person, one authorized signatory of the applicant can fill out the entire form and make those certifications. However, the banks, the lenders are required at some future date to make an attempt, a reasonable attempt, to verify that the information is true. They are, however, entitled to rely on the certifications made, and the making of a false misstatement by the applicant can subject the applicant to civil and criminal penalties under the Small Business Act, and they are significant.
Richard, are part-time employees counted under the PPP?
Yes, they are. So when you're looking at the number of employees for purposes of eligibility, you have to count both part-time and full-time. The one exception is when it comes to loan forgiveness, you basically calculate a FTE, a full-time equivalent number, and base the amount of forgiveness off of that. But for the application itself, it's full-time and part-time.
Thanks, Richard. Just one sort of follow-up on this, and sort of how it fits in with the larger conversation about what's happening in the marketplace right now and why these programs are so important. Beyond being very useful tools to help cover payroll and expense needs during this shutdown, if you are a landlord or a tenant and you're engaging in conversations regarding rent deferrals, rent restructuring, what we are seeing in the marketplace now is that sophisticated landlords, it's not so simple as tenants going to their landlord and saying, hey, I would like to not pay rent for April. Can you forgive my rent? What landlords are doing is landlords are saying, we will have a conversation with you, but we're going to need to see what's happening with you financially. You're going to have to report to us and produce your 2019 financials, your Q1 2020 financials. Show us what you have been doing in order to avail yourself of the CARES Act benefits in order to cover employee payments and rental payments, and generally demonstrate hardship for us. We're not going to allow this situation to be used by tenants as a windfall to get rental packages and deferrals. We need to see real hardship, and then we will engage in discussions with you. Some landlords are not engaging with discussions with their tenants at all, and have opted not to have those discussions. But the ones that are generally requiring some demonstration of hardship and efforts on the part of the tenant to find relief through governmental programs. So this is all part of the discussion. It's all part of the conversations that are happening right now. And it's an important tool in the arsenal of coping with the current situation and getting through it. So,
Eric, can I piggyback real quickly before we kind of off that point you just made? To the extent you're going to engage in those discussions, whether you're on the landlord side or the tenant side, you want to make sure, certainly from the landlord side, that any discussion you engage in with the tenant is non-binding and confidential. So you do not want to be bound by a negotiation with a tenant that could ultimately compromise your ability to perform any obligations that you have. And then beyond that, you don't want any individual discussions with tenants to then lead to disbursement of that information to other tenants in your shopping center, in your building, and then ultimately putting you as a landlord in a difficult situation with respect to other tenants. You want to make sure you're very clear when you enter into those negotiations Eric just mentioned, that you're doing so for purposes of evaluating a potential modification to your agreement, but that the simple discussions do not in and of themselves create any type of forbearance, any type of abatement, or even any type of deferral until it's agreed in writing by the parties.
That's a fantastic point, Dave. And that brings us up against the hour. So I will just, Beth and Richard, I think Dave that's a nice takeaway here at the end to leave with. Do you guys have anything to add, any takeaways regarding the present situation that you would leave our audience with?
I would just add to what Dave said about papering the file. If you do down the road end up in litigation, it's very important to keep that communication, as clear as possible, reserving rights, making sure you have the appropriate language. And the other thing is, some of our colleagues in Florida pointed this out about if you are in a situation where you have to give notice, if there's litigation, just keep the words litigation out of these communications, because you don't want to end up obligating yourself to raise it up the flagpole if you have an obligation to give notice of pending or threatened litigation.
Eric, one final thing from me. It has to do with conversations. Borrowers under the PPP program should also have a conversation with their other lenders. You know, in the excitement of what is essentially free money to some extent, keep in mind that you know, taking this loan could cause a borrower to blow through a financial covenant, may be subject to a loan document that contains a limitation on other indebtedness. Have that conversation with each of your lenders and basically get a waiver to obtain this loan. An argument can probably be made that it's a grant, not a loan, to a very large extent, but nevertheless, it's not characterized as such in the Act. It is characterized as a loan, so keep in mind unintended consequences.
Thank you, Richard. Thank you, Beth. Thank you, Dave. I think that was a very useful presentation. To the audience, I hope you have found this information useful. And as I mentioned at the top of the call, we are looking under these circumstances to find different ways to stay connected with all of you, make sure we're addressing your issues, thinking about your issues, and offering helpful guidance. So if you did find this discussion useful, and if it's something you'd like to see more of in the future, please provide feedback as such, because again, you know, we're all kind of feeling our way through this right now, and you know, looking for different ways to stay connected while we all shelter in place. So hopefully this was useful, and I hope you're all safe and healthy, and look forward to getting through this with all of you and to brighter skies and brighter days. But thank you all for attending, and we'll talk to you soon.
Yeah, thanks, everyone. Thanks, Eric.
Thank you.